It's the next episode of Small Business Chat. Joins me today is Matt. We're talking about some exciting stuff about Lizzie Borden. If you don't know, we'll go into some history facts about her later, but there is this coffee shop known as Miss Lizzie's that just went through a trademark dispute with another Lizzie Borden themed museum and bread and breakfast. So we're going to talk about that today, about the aftermath of that trademark dispute. But again, joins me today. Matt, how's it going?
Oh, it's going fantastic. How you doing?
Doing really good, really good. I'm really interested in this topic that we're going to talk about today. I'm really into serial killer stuff, even though I don't even know if she classifies as a serial killer. But we'll also go into some fact stuff, especially if you're listening to this and you don't know who Lizzie Borden is. But yeah, I'm doing great otherwise. Matt, want to go ahead and we can kick this off?
Well, I was going to say, so tell us what the actual trademark dispute and give us a little background of like who Lizzie Borden is and all that sort of stuff, because you had to explain this to me. So
Yeah, yeah.
who's Lizzie Borden, first of all?
Well, first of all, I also love this theme, which is the Lizzie Borden themed coffee shop trademark dispute gets an axe, which is funny because the
Ah,
the coffee shop actually won the trademark dispute, and we'll go into that. But just for anyone that's watching this or listening to this that doesn't know who Lizzie Borden is, she is a notorious figure in American history. She's primarily known for the involvement of brutal murders of her father, Andrew Borden, and also her stepmother, Abby Borden, on 19, or not 19, 1892. She murdered both of them in her home with an axe. So she's known for that. She looks like she was under investigation, including some statements from the police. And also, I think she went on trial. There was no witnesses or forensic evidence that definitely proved her
ugh,
guilt.
ugh.
But there was I think eventually went to jail for it, or I think she might have killed herself also. But yeah, that's what some facts known about her. She's pretty well known when back in the day. So, but yeah, there's some
Alleged and or convicted axe murderer of her
right.
parents
Yep.
in the 1800s.
Right. Yep.
So it's sort of a Christmas happy-go-lucky theme Thanksgiving for today.
Right. Right. There's actually a
Nice.
nursery rhyme about her too, about Lizzie Borden. She took an axe and gave her mother 40 whacks.
All right. Well,
So.
because when you actually said, first of all, have you ever heard of Lizzie Borden? I was thinking about like the milk company. I thought there was like a Lizzie Borden milk company or Borden, but that must just be me. I'm trying to think back to elementary school, what the name of our little chocolate and white milks would be. And I
Mhm.
can't remember what they were, but I thought they were like Borden or Boris. It said, anyways, but I can't imagine they would have voluntarily named themselves after an axe murderer. That's usually a persona non grata. It's like, again, it's like Charles Manson, like, cookies.
Mhm.
You're like, the cookies that
Right.
tasted so good that, well, how are you going to market that? Just,
And people find ways to market anything these days.
yeah.
Yeah, and also I did find out here it looks like Lizzie Borden did die on 1927 at the age of 66. So I would assume she was in jail for that entire time. I'm going to pronounce this word wrong, but pneumonia or pneumonia,
Pneumonia.
pneumonia. I knew I
And
was going to say
pneumonia.
that
Yeah,
wrong.
the P is silent. Yeah, so it's pneumonia. So she died of pneumonia, which is it's 60 something years old back then. Yeah, that's just means she got a little bit sick and it was time we didn't have antibiotics that, like we do today and all that sort of stuff. So if you get a little bit sick, you get a hangnail back in like the 1800s. Ooh,
Yeah.
that's doom right there. Like, oh, get your
And
affairs in order. You're like,
all
I'm only
right, and
28. And you're just,
and
yeah, you're
here's some
done.
interesting things about the trial itself. Her defense team argued that there was no clear evidence linking her to the murders and questioned the reliability of the witnesses. Lizzie's strange behavior and possible motives, including financial gain, were brought up during the trial, but there were no witnesses or forensic evidence that definitely proved her guilt. The case was sensationalized in media, and the public was divided on whether Lizzie was guilty or innocent. And then, after a highly publicized trial, Lizzie Borden was actually acquitted of all of the charges
Oh,
in
oh.
1893. So she got away with
Well,
it.
if you don't have a witness, and I mean, I'm not quite sure. It's difficult. Uh, you know, so yeah, when you go to law school, like one of the things I always say is the justice system should be tilted in a manner that it is harder to get a conviction than not. And if you're telling me like they don't, now, I don't know all the evidence of the case back in the day, but I mean, but you know, she's so famously her parents were chopped up by an axe. They thought it was basically her, but they didn't have any witnesses. And back in the day, we didn't have modern forensics or anything like that. So I mean, it would have been very, very difficult because today they come in. Well, I don't know if you know this, but like if you ever are like, you know there are things that they do when you're accused of, for instance, shooting somebody. Like they'll come in and they'll bag your hands, and you're like, "Well, what are you?" So if someone ever like gets shot in your house and dies, and it wasn't you, and they come in and start bagging your hands, ask for a lawyer immediately, because
Bagging
effectively
your
what they're
hands,
doing,
what's that mean?
gunshot residues on your hands
Oh,
and they can actually tell if you fired a weapon and such because you know because when the bolt slides back and such because I've had to deal with that in several trials and all that sort of stuff where you know a client basically said, "Oh no, you know I didn't fire the gun, I wasn't anywhere near no gun," and then suddenly it's like, "Oh well, about that, yeah, you have gunshot residue. How do you explain that on your hands?" You know,
mhm.
and such. So it's not even fingerprints, so you can't even remove the fingerprints, and it stays there for a while. But in any event, there's you know, but you didn't have modern forensics like that. And by I mentioned before, by the way, I mentioned Charles Manson cookies. I did have the opportunity once to direct on the stand one of his psychiatrists, and that was fascinating.
Really?
Yeah.
Can you tell us anything about that?
Yeah, it's all public. It was in a court case in D.C. So we were calling him as a defense witness because we thought that yeah, this injured party was a PI case. So it was relatively boring. It just happens to be this guy was bigger than I expected. So when you're basically you're going through and you're going through what's called voir dire of the expert. You basically have to prove that he's an expert before the court will
Mhm.
accept him as an expert. And part of our defense in this case was is that the woman wasn't as injured as she said. She actually just had psychological problems, and that was what was inhibiting her ability to ever work again and all that sort of stuff, aside from the fact of her physical injuries from what she had had, et cetera, et cetera. And so as I'm voir diring him, I'm preparing him. This is actually in our office. I'm like, okay, so I'm going to ask you about your, credentials and blah, 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 blah. And so have you ever treated anyone famous? He's like, blah, 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 Charles Manson. And I'm like, what did you, what? I'm like, you're on Charlie Manson's psychiatrist? I'm like, and he's like, yeah. I'm like, what was he like? And he says, one of the most engaging people you'll ever meet. He said, no, he said he's a psychopath. So he says he's very dangerous, obviously. And I'm like, what does that mean? And he goes, I'm like, is he just a complete raging jerk or, whatever he is? No, extraordinarily intelligent and
Yeah.
extraordinarily charismatic. And he says, and so I'm like, how can you tell his intelligence? He's like, a psychopath will remember every little detail about every little meeting that you've ever had with them. I mean, like, so I would, on my like ninth meeting with him, he's like, he could tell me what I was wearing down to the color of my pocket square during our third meeting, everything that we talked about verbatim. He says, I mean, he's tantamount a genius, but obviously psychopath and a horrible person, and we're glad he's no longer on the face of this planet. But that's why they study those guys because they're trying to figure out how do we predict the next one and how do we stop the next one when we actually see those jackasses out there, and all that sort of stuff. But anyways, I got a chance to actually, meet one of his people. I did not get a chance because I'm not old enough to meet one of Lizzie Borden's people that may have treated her, assuming that she did it. She got acquitted. So technically,
Right,
under
right,
on
right.
our eyes, she's innocent, and such.
I think
Um,
she did it, but that's just me.
yeah,
Um,
I've never read up on anything. But anyways, back to the trademark then dispute on all of this.
Yeah, yes, let's get
That's
into
my
that. So,
backstory.
reading from the article now, a federal appeal court on Friday upheld the right of Miss Lizzie's Coffee, a cafe that moved in next door to Lizzie Borden's house in the Fall River, Massachusetts in 2023. They continue the patrons use the name that pays homage to the home's grisly history, according to the Herald News. So the coffee shop's signage, which features a cup of coffee and an axe with a bloody knife, spurs a
Hmm.
lawsuit by U.S. Ghost Adventures, which runs the bed and breakfast and museum at the site of the unsolved murders, the newspaper reported. So that's the between the trademark dispute from the bed and breakfast museum and versus the Miss Lizzie's Coffee. So
So in essence, the Bed and Breakfast Museum, so I think we can understand, is basically the home where the murders occurred, and now a company has turned it into a museum slash you can stay there as a bed and breakfast if you're into the how do we pronounce it? The macabre,
Hmm.
basically like the dark shit. That's
Right.
right and such.
Matt, would you ever want to sleep in the same home of where famous murders took place?
No. And your wife's a real estate agent, and so she knows she has a legal obligation to disclose when someone has died in a home, or
Hmm.
maybe not died, murdered. You have a legal obligation, I know, to disclose if you know there's been a murder in the home.
I wonder if I mean my house was built in 1905, so
Oh, you've had so many people die in that damn house.
oh, thanks, Matt. Appreciate that. Luckily, I have not encountered, I've lived there for a year, I've not encountered any sort of
Let me guess.
supernatural.
Crawl space, right?
Was done after
Yeah,
the fact, but
yeah.
yeah.
Yeah, you ever look under there?
We still have the old school storm door that in case of tornadoes you open. It has been built over, so whoever lived there before us has put some sort of roofing on top of it, so you can't even get in there anymore. But it was one time a hatch where you could get underneath the house in case
Yeah,
of.
well, when you have a pet cemetery underneath your house, that's what they usually tend to do.
Don't stop it, Matt. Stop telling me
No,
that
actually,
stuff.
no, but actually, the good news is because your wife is a real estate agent, she would have
Hmm.
known. She
Right.
would, because I think I think there's a like they literally have to disclose. So is it possible someone has passed in your house? That's a lot different than saying someone was murdered in the house, and there's a distinction between the actual two. But then rolling it back into the Lizzie Borden thing, ooh, no, no, I wouldn't. But you would, wouldn't you? Or because you said you're sort of a fan of this type of stuff, not fan, but you know what
I
I mean.
mean, so I mean, I
Interesting.
probably would, but at the same time, I've never encountered anything supernatural in my lifetime. I think that type of stuff is really cool. Me and Destiny actually,
I don't know.
me and my wife went to a haunted city, not city, town. It's up in Virginia. I can't remember what it's called, but it's a whole town that has a whole bunch of historical supernatural appearances. I actually did get a ghost on camera once. Like I literally took a picture. They said if you take a picture at a certain angle on this house, you can see stuff in the image if you zoom in. That's the closest thing I've ever gotten to anything supernatural before, but um,
Wow.
so I would
Wow.
just because I'm into that kind of stuff. One question I did have about this, which you possibly would know the answer to this. The bed and breakfast place filed a restraining order to the bar of Miss Lizzie's from the use of the signage. It
Okay.
argued it amounted to trademark violations. How do you file a restraining order
It's just basically
to
a
a
part of a standard
location?
filing or pleading that you can actually file in a court of what we would call competent jurisdiction. So, depending on if their claims were federal, which they likely were, they probably should have filed it in the quote unquote local federal courthouse, because you're
Hmm.
dealing with, U.S. trademark rights. But they probably could, they may have filed in the local and then just it's called a pendant jurisdiction or something like that. And you can argue federal claims in a state as long as you have underlying state claims as well, and people have a right to remove it to federal court. It gets complicated, but you basically just file it in a local court of competent jurisdiction to argue that. And what you typically have to do to show, basically get a restraining order on somebody from using a national trademark, either temporary or permanent, is show to the court a likelihood of success on the merits in an early, basically you file for the larger case, which is maybe the actual complaint against them for trademark infringement with all damages and all that sort of stuff. But you then ask for the court for a temporary or a permanent restraining order against them ever using the actual trademark again. And in order to get the temporary restraining order, you then have to move and make a motion for a temporary restraining order pending the full trial of the case. And it's a pretty heavy burden to actually meet just because you have to show both in a hearing a likelihood of success on the merits and then the fact that the harm is irreparable, so that otherwise damages would not be sufficient to actually cover any damage that is ongoing between now and when we can actually get this thing to a trial. So in other words, hey judge, not only are we going to win when we put this in front of a jury, but if you don't stop this now, we're going to be out of business. So please, can you stop this now and look at how similarly it's marked? So where I would say it would be something along the lines of is if you had a very distinctive mark like, Coca-Cola, for instance, and you were just a young startup out of Atlanta, but then, someone starts using Coca-Cola down the road from you, clearly trademark infringement, identical trademarks, identical products, but then you can go and show your sales have plummeted so much that you're not even going to be able to afford to make it to trial. And the judge can look and say, okay, you were using it first. Hey, second Coca-Cola, when did you start using it? Oh, well, Your Honor, we'll prove it at trial, but no, just shut up, answer my question. When did you start? Oh, well, we used it after. Are the marks identical? The goods and services? Yeah, I think you're going to win this case. So I'm going to enter the temporary restraining order. You guys can go through and defend it if you want. And because they're showing now financial argument that they're going to go out of business because you're stealing other business, but clearly you are infringing on their trademark. That's the type of situation you get a temporary restraining order over from the court, which then leads to a permanent restraining order, which is part of the standard damages that you seek in an actual trademark infringement case. Answer it?
Gotcha. Yeah, perfect answer. I'm just so used to when I hear restraining order, first thing I think of, so the people from the coffee shop place can't step foot in the museum. That was my
Oh,
first
yeah. Also a possibility, you
false
know,
possibility.
you
How
know,
would they know?
yeah.
How would
I,
they
but but the
pictures up on
marks
the
aren't even
wall?
identical, right? I mean, I'm assuming that the bed and breakfast is like called like the Lizzie Borden house, just very plain and simple. And then it's like Lizzie's, you know, I don't know, Lizzie's coffee shop or whatever next door. You said the
Well,
coffee shop one,
yeah, well, I'm looking at, so the bed and breakfast place, the museum, just has Lizzie Borden's name on the sign in cursive or cursive look writing, and then
right?
underneath it just says bed and breakfast on the sign. And then for the coffee shop, it just says the Miss Lizzie's with a coffee cup on it.
Right.
So
I mean, the first thing you can do to start tearing this down, because I know the question's going to come, is what would you think about that? So there are a lot of issues that would implicate this. Number one, how does the society own the trademark Lizzie Borden? But they own Lizzie Borden's presumptively it's a bed and breakfast, so it would be like, they may have it. Well, first of all, they would have it for hotel services, right? Which I don't even know what class that's in. But this is all I'm assuming this, which that always makes an ass out of you and me. Assume, but anyways, but secondly, like okay, so it's a bed and breakfast, so so they probably have a restaurant, so they do have restaurant services for Lizzie Borden. No, the questions that I go through is okay, so how do you have exclusive rights to use the term Lizzie Borden, a former famous dead person? Like, did the estate actually is there an estate that actually claims those rights? Do they have rights through that? Like, or do they just have it because by virtue of the fact that it's a famous person in history, Shakespeare, Ben Franklin? Like, I mean, there's Franklin Investments is always a great example. I'm like, do you think they actually got Ben Franklin's descendants to actually sign off on that, or no one actually owns Ben Franklin's rights anymore, so you can actually just file for it? So did anyone own Lizzie Borden's trademark rights? Was there an estate out there? Because, for instance, we once represented the estate of Orson Welles on an attempt, which I think we were successful at reclaiming the trademark War of the Worlds from his famous 1930s broadcasts that sent, people plummeting out of windows because they actually thought we were being invaded by Mars, and such.
and then
And
the Tom Cruise movie,
and then the Tom Cruise movie, exactly, which was not bad.
which
Anything
kicked
with Tom
ass.
Cruise is good,
Yeah.
yeah. But we were able to represent one of his many children. One of the challenges that we actually had in representing her is that she was the legitimate heir to Mr. Wells's estate, and such, because Orson, do you even know who Orson Welles was, by the way?
Mm-mm.
He's beyond you.
No.
He made a film. He was a very famous director from Hollywood in the heyday of Hollywood, who made one of the most innovative Hollywood films of all time, named Citizen Kane. And so, but he was famous for so much, more. And later in his life, he plumped up, shall we say? But he was always a very famous director, deep baritone voice. Orson, well, just very, very famous director, et cetera, et cetera. Sort of like almost like, sort of the Hitchcock generation. But one of the most famous directors in the history of Hollywood. In any event, but he was known to having houses around the world, et cetera, et cetera, and had sired children with, we'll just say, multiple people, and I believe multiple people like his housekeepers and stuff like that. And so we represented one of the children, and we had one of the big challenges was proving a line of succession that she, in fact, was the legitimate heir to the Orson Welles estate. Then, once you got past that hurdle, that okay, she should have this, then you had to go back and say, okay, where you been for the last 70 years? Or well, he's only been passed for I think about 25 years, but where have you been? Say it's 2000. No, he died in like the 80s, so about like 35 years or something. But anyways, where have you been? and so you have to connect the actual rights. So drawing this back into our Lizzie Borden thing, the first question that I always would have was, okay, so, you know, was there an estate out there for Lizzie Borden that could have claimed her name, and or if there's not, and I'm pretty sure I don't know the answer for Franklin Investments because they actually have a picture of Ben Franklin on a big, very wealthy fund and all that sort of stuff. You know, can you just use a famous persona's name before and all that sort of stuff if there is no heirs, if there no, and I think the answer is yes. But first things first, if I were defending the case, I would have looked and see if there's a legitimate heir to Lizzie Borden's estate, and I would have then bought any of their trademark rights from them as part of my defense. And be like, well, while you guys were suing us, we actually became the legitimate owners of that because we actually purchased it from her granddaughter. So about that, sorry, not sorry. I
We
mean,
all know all rights to the
we've
trademark.
actually done stuff like that. So for instance, you get sued by there's a thing that we used to actually do. And it's a little tip for trademark holders out there. If you ever get sued by infringement. So let's assume that Coca-Cola analogy again, right? I know I'm going a little bit off topic. I'm sorry, it just popped in my head. One of the things that I've used at least 3 times in federal district courts, and it actually worked. And it was so we get sued. Coca-Cola gets sued by Coca-Cola, and it's dead on infringement, all that sort of stuff. Well, if I'm the person that's going to go and try that case, I'm going to get my butt handed to me at trial. I'm going to throw up a Hail Mary here. What was the Hail Mary we came up with once? We searched the country for another brand that had somehow used Coca-Cola, even if it was in like another state, okay, like just and they'd never left the state, for someone who'd used it before the plaintiff, and we actually went out and bought it from them. And then once we bought it, our rights leapfrogged over those of the plaintiffs. And we're like, so then you walk into settlement conference and you're like, oh, so about that, how you're demanding all this money from my customer? Yeah, we bought their rights, and I don't think there's, and you've already put in discovery, you started using it in 1907. Well, we started using it in 1842. So who's writing who a check today? So, and usually how those settle out is just it's you cloud and murky the waters enough that the plaintiff's counsel doesn't want to deal with that anymore at trial, and so they just resolve it. No money changes hands, and you do a concurrent use or something like that. But it's one way. But if I was in the position of that, Lizzie's coffee shop or whatever it is, that's one of the things I would have thought about. But you said they just straight up beat them. Like, so we're talking about
Yeah,
ownership issues, but now we're just talking about, okay, they said no.
yeah, I have actually something really interesting to bring up, and I would love to see what you think about this. So, I looked up Lizzie Borden, and for in the USPTO system, and the U.S. Ghost Adventures, which is that bread and breakfast place with the museum, actually owns, let's see, 3 different trademarks. Actually, more than that, 5 from what I'm seeing. They own Lizzie Borden Museum. They own the trademark Lizzie Borden for hotel and restaurant services. They also own conducting, guiding, walking tours of city for Lizzie Borden ghost tours. They also have Lizzie Borden underneath of decorative magnets, jewelry, ornament pins, and they also have Lizzie Borden registered underneath of metal keychains as well. And then, so they have all those trademarks. But then I look up Miss Lizzie's, and I actually found where they did file a trademark for it, that coffee shop. And right now, their trademark is abandoned, but did get accepted. The USPTO did not find anyone similar to them. All they needed to do was just fix their specimen and disclaimer. So right now they're
Wow.
abandoned.
And they let it go. And maybe they let it go because they were getting sued by these people and they're just like, well, it's just, it's too much money. They're a
Well, it's no
coffee
longer
shop.
an issue now.
Yeah, well, but they're still using it. They may have abandoned it before the Patent and Trademark Office, but they're still using it. And I think they have gotten sued to say stop using it as
Hmm.
well. And so they may have thought, well, we're not going to, but it's fascinating. Well, the first thing is a shout out to the examining attorneys of the United States Patent and Trademark Office. It's if likelihood of confusion usually comes down to how close are the marks and how close are the goods and services. Now, they'll tell you there's like 6 or 8 other things that they consider. I'm going to tell you 99% of it is those 2 things. How close are the goods? And so the examining attorney who had this on their desk, his or her desk, found there wasn't a likelihood of confusion. And by the way, there's always an argument as to whether or not you can bring that in to trial at a subsequent, like actually infringement case. The fact that an examining attorney has found it. I never got to that point, but I always considered if when that type of thing actually occurred, whether or not that I would actually, subpoena the examining attorney, and whether or not it was relevant, because we always had to debate whether or not you could actually do that. And I have to, well, your legal opinion is, and then, well, that's expert testimony. Like, yeah, but it's like the expert. It's the United States Patent and Trademark Office didn't find a likelihood of confusion with this. So I wonder if they got that in before the actual court that, and I think there's statutes that say you can't do it or whatever, but I mean, I would have tried it anyways, especially if you're in front of a local court. Maybe it's reversible error, but what the hell? I'm going to try. But anyways, it's fascinating. So it's Lizzie's Coffee versus Lizzie Borden's. I don't think, did you rattle off on all the things at the original, Lizzie House or whatever it is? I don't think you had one for restaurant services, did you?
Let me see here.
Because remember, goods and services and how close is it? It's not, it doesn't say Lizzie Borden, it just say Lizzie's whatever. And even though it's a reference to that famous person, that person's a famous person. And if the Lizzie Borden house doesn't own, excuse me, it doesn't own the estate rights to Lizzie Borden's stuff, I think it's a lot harder for them to go after something that just says Lizzie's, especially if there are other Lizzies in the class out there. Like they don't own the exclusive right to Lizzie, the word.
So here's all the trademarks that they own. They own Murder House, which was abandoned, so that one's dead. Ghost Daddy for
Who's your
novelty
ghost daddy?
toys. Who's your ghost daddy? Novelty to toy
Who?
items. Lizzie Borden Ghost Tours, which that is conducting guided walking tours of the city. Lizzie Borden, that's for hotel and restaurant services.
Yep, there it is right there. Okay, yeah.
Lizzie
So
Borden
it's somewhat
Museum,
close.
museum services. They also own a trademark, and it's registered for coffee mugs and wine glasses. That's actually a drawing, a little like a cartoon drawing almost of Lizzie Borden's face. So they own Lizzie Borden's face.
Yeah.
They also had at one
I'll just
point,
say right,
right?
right where you said restaurant services,
Yeah.
it's from me, from a legal perspective, I would say there was an overlap in the goods and services. Restaurant services to coffee shop services are absolutely close enough. So it must have just come down to the appearance of the marks, and maybe just because and even though we know that a standard character mark, that means one without any pictures or anything like that, just the words alone, you can, is the broadest protection you can get for those words because you protection any font, anything. But maybe they're just simply saying that, number one, since she was a famous character in history, but number two, since it's not identical marks, it's Lizzie Borden versus Lizzie, and then whatever, and then they got the extra acts in there. The marks itself was sufficient. It's like so like, well, you don't own exclusive rights to the name, you own exclusive rights to the trademark in these various services, but you don't just own exclusive rights to the name Lizzie. And so accordingly, we add an axe, put coffee shop on it. The Patent and Trademark Office's examining attorney must have felt that it drew it far enough away from the other ones that they said okay. But likewise, the court must have examined it and say, to be candid with you right now, if I'm the court right there alone, that decision by the examining attorney to me would be determinative of the temporary restraining order effort. And so what maybe happened is they denied the temporary restraining order because what I say at the top of the broadcast here, the first step is likelihood of success on the merits. Well, you've already had an expert at the Patent and Trademark Office say there's no likelihood of confusion. And to me, I would submit that as I'm in the defense and say, the USPTO has said there's no likelihood of confusion here. So I don't know how they're going to succeed on the merits. And if I'm the judge sitting in a local state court, and what state is this?
Massachusetts.
Massachusetts. I'm not gonna go and pick up, my trademark 101 book and have my law clerk look up all this sort of stuff. I have an expert from the United States Patent, it's like the Ohio State, the United States Patent and Trademark Office says there's no likelihood of confusion here. Done. I mean, I just tell the plaintiff's attorney, what do you have to to counter this? You know.
What's really interesting is they did not get a merely a surname, so they
Yeah.
didn't get a merely surname refusal or anything, even though there's Lizzie's in it and it does involve.
Well, it wouldn't be surname because you got it's just Lizzie's first name, and surname can be avoided by putting first and last name in it, and
Mm.
the first name wouldn't be a surname alone. So yeah, so you wouldn't have that. I would have thought maybe 2A possibly could have applied because we shouldn't be profiteering off of murderers' names. Like again, coming back to the Charles Manson thing, like would they register Charles Manson? Okay, this is gonna be bad. Charles Manson, surgical equipment. Sorry if you know anything about the story. That's a really horrible joke. But the point would be is we're not going to allow people to profiteer, at a U.S. trademark context off of the horrible things that they've done. Like, so for instance, taking it to a very good example here, Lizzie Borden axes. Would they? I would think the Patent and Trademark Office would have some sort of refusal, possibly under Section 2A, under their belt, wherein they could just simply say, you can't murder a bunch of people. Same thing as like if you had an assassin or someone who's shot at somebody, and I don't want to say anything because we don't want to get our thing banned, but like if someone who's famously shot at somebody, like Sirhan or Hinckley, John Hinckley shot Reagan, John Hinckley,
On Wilkes
firearms.
Booth.
John Wilkes Booth firearms. Yeah, that'd be a better example because he was back in the 1800s as well. It's like we're just not going to allow you to have exclusive rights to actually, because effectively you're using a horrible event, something that we just should. That to me is offensive to my consciousness, and I think that's what Statute 2A was about, that we use in the Patent and Trademark Office. Not necessarily that we have naughty words and oh no, because who knows what that is. But I think that we shouldn't allow people to profiteer off of literally felonies, especially felonies that result in the loss of human life. So that's my 2 cents worth. And I would have thought that, maybe so coming back full circle to our friend, like maybe Lizzie's got through, the Patent and Trademark Office. I'll always defer, they're the experts. But maybe they got through that, but I would have thought there would have been maybe a stronger 2A look at them. They really would have looked out of the side of their eye. I mean, wait a minute, we're going to let, a murderer's name be used for this. But flip side, it wasn't used for axes. It was used for coffee shop. And that maybe one of those things, if they came in for axes, the Patent and Trademark Office would have been like, no, on policy grounds, we're not doing that. Kevorkian needles,
Right.
stuff like that. Anyways, my
Which
thoughts.
is also really interesting, funny as well. The museum and the Bread and Breakfast also has trademarked. I looks like somebody just took a picture of it. The top half of an axe with the axe part cut off looks like somebody just broke it.
Yeah.
The wooden part off, and just kept the axe portion. They have that trademarked underneath
Yeah.
of all of their stuff too, which is very interesting. It looks like literally somebody just took a picture of the top part of the axe and
Yeah.
trademarked it, and
That's
that got
wild.
accepted too.
Yeah.
So to
So let
finish
me,
it off here, go ahead.
Yeah, I was gonna say because so let me just sort of wrap this up for our listening, the 6 people that listen to our things. So from what I got out of this, so just this one is the fascinating thing, by the way. So that's cool. Thank you. Nice spot on this one. So just basically what I thought I just can wrap this in is that the trademark issues that are implicated is number one, if you have a deceased famous person, number one, do their rights, by the way, can pass down to an estate. So you do have to, look first, and you can pass your trademark rights down to an estate as well, like, and such. So you could go down and basically such. So that's one thing. But if no one owns it, Ben Franklin or something like that, then you potentially can have rights in it, and that's fine. So the implications of this are is just be leery of, people who are no longer with us. Their estate could actually own the trademark still or the name, and such. Number two would be as if you ever do get sued for trademark infringement or whatnot, contact a great attorney or contact us here and we'll get you out to somebody because we don't, the trademark company doesn't do that sort of stuff. But you do want to basically consider all your options. Consider a really good attorney that knows how to play things outside of the box, doing the leapfrogging trick we talked about, or something to that effect. But again, they need to show a likelihood of success on the merits and then that irreparable harm, if they're going to get a restraining order against you, and then just general trademark principles, which is when you're dealing with a likelihood of confusion. Again, the people at the Patent and Trademark Office, for the most part, are extraordinarily well trained, and they're in making these decisions. But if you're ever clearing your trademark or anything like that, or want to know if someone else is infringing on you, you really, really want to focus on 2 things: how similar are the trademarks, and then how similar are the goods and services. And if the goods and services are identical or very, very highly similar, it needs to be less similar on the trademark side. Likewise, if they're identical trademarks, it's sort of a sliding scale. You need to be less similar. You don't have to be as similar on the goods and services because people may assume what's called an expansion of marketplace theory, that you're allowed to expand into different marketplaces. But I just wanted to wrap that up into a nice little bow for us here today. Back to you and your your Christmas themed, trademark stuff today.
Well, I have two last things. I just want to use it as a kind of a real world example. Let's just say Lizzie Borden lived today. So she lived today, and it was a year ago that the whole Axe thing happened. She got acquitted, and she's out. So then it obviously becomes a famous case, just like it was back then. Let's just say, what would happen if somebody tried to trademark her stuff? Would Lizzie Borden then be would everyone have to go to that living person before being able to trademark any of her stuff? Or how would that all occur? Well, so like just for example, if just with the whole Hawk Tuah girl, right? So a lot of people tried throwing out trademarks before she even got famous, and that's one of the reasons why she's having issues with her own trademark in this sense. But if it's something regards like because obviously Liz Borden's famous for the axe murdering. How would that work nowadays? How would she even protect that, even though she's not trying to put,
Right.
I guess,
I think a perfect
sights on
example,
herself?
if I may, and I'll just grab it and twist it for you. Eric and Lyle Menendez, who are convicted and admitted to murdering their parents. And
Right.
then now I think they may be getting out of jail after all these years and all that sort of stuff.
We'll
But they're a
see.
perfect example because they're alive, right? And so it's an absolute boom, convicted of murder and all this sort of stuff. So if someone tried to, I think it'd just be like the same thing as for any patent and trademark already has a statute in that, and it's a living individual, right? And so
Hmm.
you would have to get the consent of Eric or Lyle Menendez to put their name on any products. It doesn't matter if it's pasta sauce or, whatever. But because they're a living individual, you would have to say, yes, they are a living individual and a consent is of record. And could Eric and or Lyle Menendez trademark their names for products and services? Absolutely. There's nothing that would block them from doing that unless, by the way, because we've talked in previous episodes about Michael Jordan, Michael B. Jordan, unless there's already an unrelated Eric, Menendez, unrelated to the person who was convicted of killing his parents, out there, and they've already registered it for pasta sauce. But assuming that that's not the case, they could actually get it. But you and I couldn't go out and register that because they're a living individual who have not given their consent to us, just like the old Michael Jordan Nissan things that we talked about and all that sort of stuff ad nauseum, which is I can't walk out and just be like, oh, I'm going to open a Nissan dealership. I'm going to call it Michael Jordan's Nissan because I have no association with Mike Jordan. Okay. Okay. Well, some association. I've called him a bunch of times and he did write back, but it was, it's like the letter said something like cease and desist from all attempts to contact Mr. Jordan or something. I can't
Restraining
remember.
order.
It's fuzzy. Yeah, something like that. I don't know.
Yeah.
Sorry.
Awesome.
It's a joke.
Awesome. Well, just one last thing. As we do on some of our other episodes, infringement or no? What do you think, Matt?
I'm gonna actually buck the trend. I would actually disagree with the court. I actually think it was infringement. That's just Lizzie's
I do
versus
too.
Lizzie Borden, and then they had it for restaurant services. I
If
actually think
if
it was
you
infringement.
if you look at it, if you look at the because I just looked it up as well because I looked it up before we even had this podcast, but I looked it up the actual location where the coffee shop takes place. They got a huge picture or I don't know, maybe it's even a sticker on their actual window outside of the coffee shop. They got Miss Lizzie's on the sign itself. They've even in the restaurant, they've got pictures of her all over the walls and a big sticker on the wall inside the
Yeah,
actual coffee shop itself too. So obviously there's a lot of involvement with Miss Lizzie. So I guess I mean my opinion, yes, I do think it's also
yeah, I
trademark
think it's yeah,
infringement.
yeah. In respect to the patent and trademark office, but
They don't
respectfully
even have a
disagree.
trademark yet. Their trademark's not even accepted or anything either. So I don't know
Yeah,
how
but if
this
you're saying
claim's.
they didn't get a likelihood of confusion, but they abandoned, on procedural issues, so they would have gotten it. Respect to patent and trademark office, respectfully disagree based on everything that we know. If I were sitting on a jury, I probably would have said, yeah, infringement, but not enough for a temporary restraining order. I would have basically said, no, no, no,
Now,
you guys got to go through and get this, you got to
now
prove it.
is it possible? Let's just say, for example, the people who own the coffee shop went through submitted the proper paperwork for getting the abandonment turned over, and they handle the procedural issues. When the USPTO has their turn to respond, can they also do another search just to double check their work, or is that final statement of there's no conflicting marks, does that still stand firm, or can the USPTO come back and say, no, we actually did find
Okay.
these other
Yeah,
trademarks?
so I think what we're probably seeing is on the outside, what's probably happening is, I think probably what happened is they entered into some sort of settlement whereby they're just like, let's resolve all this, but just don't register it as a trademark, continue to use it, and we're happy. And that would be my guess looking at this from an attorney's perspective. What you just asked is a whole new massive ball of wax because the answer to your question is theoretically no, but absolutely yes. So your question, just to restate it, is can the Patent and Trademark Office research this, when it comes back up? And so without getting too much into the internal workings of the Patent and Trademark Office, it's changed over the last 20 years in very brief. So the examining attorneys used to have the final say so, approved for publication, it's done. What we now know is they put in a two-part system with less experienced examining attorneys sort of giving a initial thumbs up or thumbs down to it. But then I believe that they now have a core of more seasoned examining attorneys that everything that is approved for registration effectively gets re-examined. And that's why sometimes you do see them getting, you know, post-publication refusals, which was not a thing 20 years ago.
Mhm.
It just wasn't. But today you actually see it. Come to think of it, I don't know if you, well, excuse me, I don't do this anymore, so I don't see anything anymore. But I know for a while, several years ago, you saw a wave of them, and I just don't know if that still happens or not. But maybe it's because they were implementing a new system as how this was worked. But again, I'm far removed from that, years removed from that now. So, who knows? But anyways, back to you as we wrap it up.
Awesome. All right. Well, thank you for everyone that's listening today. Hopefully you learned something. I thought she went to jail or died in prison, whichever, but that wasn't the case. So I learned something myself today as well. She was acquitted, which is crazy. But back then, I mean, the things that were available at the time that are available now to kind of find the exact person who murdered those people. I mean, we'd be able to know exactly what, if this case happened now, we would definitely know. But so it's fun to know these types of things. History lesson today for everyone that's listening. As always, this episode is sponsored by the Trademark Company. If you have any need to trademark your business, trademark a logo, trademark an axe handle, whatever it is, come to the Trademark Company. Go to the www.trademarkcompany.com. Find us, and one of our lovely agents would love to talk to you about protecting what's yours. So, as always, myself, and Matt, thank you for listening, and hope you have a great rest of your day. Thank you.